Welcome to the module on modes of interpretation. During the introduction, we talked about President Carter in 1978 signing the Court Interpreters Act that made it federal law, and in that decision, the courts had to abide by the law. And the law states that when a person is unable to communicate in English, whether because they can't speak English at all or because they are limited in their English proficiency, that the court should provide interpreters for them. In order to comply with the new law, the federal government started doing research to determine who should be appointed to be a court interpreter in federal courts. They interviewed people in the area of linguistics, interpretation. They consulted with people from other countries and also with attorneys and judges in this country. And they produced an interesting summary of the minimum knowledge, skills, and ability required by the interpreters to work in a court of law. The summary included, first and foremost, that every element must be preserved. In other words, an interpreter cannot leave out things that he or she considers unimportant, even if they are as simple as a yes or a no or a sir. They must preserve every element. It is not up to the interpreter then to decide what information is interpreted and which one is not. 2. The flavor of the speech is important to make judgments about credibility. This is an important feature about court interpretation because when a person cannot understand, for instance, a witness from the witness stand, that person relies on the interpreter to capture not only what the person said, but the tone and the intent of the speech to the best of the interpreter's ability. So for instance, if a person sounds a little hesitant in one language, like, well, yeah, I guess I did, the interpreter shouldn't just say yes, because that would definitely change the ability for the triers of fact to decide if the person was hesitating or not, maybe being truthful or not. Number 3, the witness should not be interrupted. This is one of the tenets of good court interpretation. Because think about this. Think about any time that you're telling a story to somebody and you get interrupted. What happens? Exactly. You lose your train of thought. You don't remember exactly where you were going with the story. Or at the very least, you will start maybe at a different place where you were before. Court interpreters have to have the ability to let witnesses testify and then interpret what they said completely. There are studies out there that show that when a witness is interrupted constantly by the interpreter in order to interpret just very short portions, the witness is perceived as less credible, sometimes even less intelligent, because the jury or the triers of fact are listening to them in very short, cut-up sentences. Number 4, very important. If you're going to be a court interpreter, you must be able to do simultaneous interpreting. Why? Well, I think it's one of the most important lessons we learned from the Nuremberg trials in 1946. That when you have a court of law and we have defendants and prosecutors and judges that don't speak the same language, especially in the case of Nuremberg where we had 4 different languages being used at the same time during the trials, the interpreters could not practically go into the consecutive mode. They would have to be able to interpret simultaneously directly in several languages, so each person decided what language they would understand and listen through headphones. Interpreters should never give legal advice. Obviously, most interpreters I know that are working in courts would never dare to talk about legal issues or try to give legal advice to any individual. But sometimes interpreters don't even realize that something that sounds very, very innocent could also be construed as legal advice. A simple question as to what to do next, that the defendant would ask the interpreter, what should I do next? The interpreter might even give a very short answer like, well, most people do this, or most people, or last time I was here, the person did this. Any advice is legal advice, and interpreters should never engage in giving legal advice. The committee also gathered information to understand what is needed for an interpreter to be able to deliver the message correctly. And the studies show that a person that is going to be interpreting in court needs a comprehensive knowledge of both languages and never misrepresent the level of sophistication of the speaker. Our friend Patricia Mickelson King always says, if a person sounds like a PhD in one language, they should sound like a PhD in another language. If they sound like a low-level education, a peasant person in one language, that's the way they should sound in the other language. We never misrepresent the level of sophistication. Interpreters are constantly acquiring new vocabulary and techniques because we need a comprehensive knowledge of both languages. And when we talk about conservation, we need to understand, as court interpreters, we have the obligation to render form and manner, including pauses, hedges, self-corrections, and emotions, but only with a tone of voice. As an interpreter, actually, you should not reproduce gestures. Because if a person makes a gesture pointing to one part of their body, like saying, I was hit right here, if the interpreter were to repeat the gesture, then the triers of fact, instead of seeing it only once from the witness, they would see it twice. Moreover, the interpreter might point not exactly in the right part of the body or section, and that would change the perception of the triers of fact. But yes, we do reproduce emotions with the tone of voice. If a person sounds indignant, like, why are you asking me those questions? The interpreter should sound the same way and not in a very robotic, why are you asking me questions? Because then again, the triers of fact would not perceive the emotion included in the message. Our job as interpreters is convey the meaning both ways, to preserve the tone and to literally place the person in the same circumstances as a person who speaks English in a court of law. Therefore, we must interpret without omissions. We cannot leave anything out. I cannot stress this enough. Sometimes I see colleagues that when they're interpreting, they start making judgments as to, well, if the person said, well, I don't need to say that. Or if the attorney says, for instance, strike that. Oh, well, if we're going to strike it from the record, I don't need to say that either. Us, court interpreters, cannot make these decisions. We need to interpret everything that is said without omissions. Also, accurately without distorting the meaning. It's important for you to understand that when you're interpreting, accuracy includes even very small variations in meaning. For instance, if a person was walking briskly or rapidly, the interpreter should not interpret A, walking, or B, running, because neither one of those solutions actually and accurately sends the message of what the original message was. So if the person was walking briskly, you need to find the equivalent in the other language to convey that meaning. Also, let's think about somebody being slapped in the face. Well, slapped on the face and punched in the face are completely different actions, and the triers of fact should perceive exactly what the witness said. We cannot change style or register. What does that mean? Well, when we're talking, when we're communicating with people, we tend to use either very sophisticated language sometimes, educated words as they say, or more colloquial terms. Let's assume, for instance, that the attorney is using very high register, very elegant legal solutions, and is saying something like this. Do you see the police officer that effectuated the arrest? The interpreter should not make a judgment and say, well, maybe that's too high of a register, so let me just make it easier for the person to understand, and I'm going to interpret something like, do you see the cop that busted you? Even though it's the same meaning, it's not the same register. Likewise, if the person is using very colloquial, informal speech, the interpreter should not change it to more formal register in order to make the person look good. Without additions. Sometimes we tend to analyze too much and think that maybe there's more meaning beyond what was said, and we try to complete it. Or simply, sometimes we decide that we're going to be polite. This is very common in court, that what we call questions during presentations, for instance, at the witness stand, that not every question is really a question. Sometimes there are commands. And it's very common to hear an attorney or a clerk tell the witness, state your name for the record, which is really not a question, it is a command. And I have heard many of my colleagues add a little bit to that and say, in their language, please state your name for the record. Seems harmless, but again, we're adding information that was not part of the original message. If we start allowing ourselves as interpreters to add information or to change the politeness of the utterance, all of a sudden we're not interpreting what the person said. We also, on top of all this, we have to be able to do it with as little delay or interference in the routine pace as possible. We cannot delay, and we cannot make people wait for long periods of time in order to get the message to them. In a court of law, we use 3 modes of interpretation. The most common, I think, from the point of view of understanding interpretation, is the consecutive mode. My idea is that if we think back, and I'm sure you can surmise this very quickly, us interpreters have been working as interpreters for many, many years, centuries, because as soon as two peoples could not communicate with each other, as soon as there was a barrier, a language barrier between two peoples, one of us, many years ago, jumped in and started mediating. And it is my theory that they did it in the consecutive mode. What does that mean, the consecutive mode? In a court of law, what that specifically means is when you're using this mode as an interpreter, you will hear somebody, for instance, an attorney, asking a question. You will hear the whole question, let them finish the question, and after they have finished the question, you will interpret the whole question into the other language. In the same way, once you hear the answer, you let the person answer completely the whole answer before you say anything, and then you interpret the whole answer for the record. Whether it's on the record, in a deposition, or any other situation where you have to use the consecutive mode, always remember, if I'm in the consecutive mode, if somebody's talking, I shouldn't be talking. I need to wait until people finish, and then I interpret the whole utterance. The second mode of interpretation that we use in court is called side translation. Side translation is a hybrid. We actually use the word translation, which is usually reserved for when a person transfers meaning from a written document to another written document in another language. That's a translation. We call our profession interpretation because we do it orally. But in this case, a side translation is really a hybrid. A side translation is nothing more than an oral rendition of a written document from one language to another. Side translation in courts is quite common, even though people don't think about it that much, because many times when the accused are brought into court, they are given documents to read, and of course those documents are written in English. That's when you, the interpreter, are going to be asked to side translate documents from English into whatever language of expertise you have. Side translation is commonly used from English into foreign language, but sometimes, infrequently, you might be called to side translate a document written in a foreign language for the record into English. Last but not least is the simultaneous mode. In the simultaneous mode, we are actually going to be speaking at the same time as somebody else. The simultaneous mode is used in court specifically when people are speaking English, and the non-English speaker or limited English proficiency individual that we are interpreting for must be made present by understanding what the people around them are saying in English. It is your job as an interpreter to keep interpreting simultaneously the whole time that people are talking around the NES individual. Remember, when you're doing simultaneous, all the previous rules apply. You can't leave things out. You can't change the register. You must continue in the simultaneous mode for the benefit of the non-English speaker. Now, let's start discussing when do we use each one of the modes. Let's start with consecutive. Consecutive must be used at the witness stand. It is the mandatory method to be used when you are interpreting for a witness that is being given testimony at the witness stand. If the attorney is asking the question, you wait for the end of the question, and the same for the answer. Also, even if you're not on the record, even if you're not in a court of law, if the LEP or NES, limited English proficiency individual or non-English speaker, is being deposed, then you, the interpreter, will continue to use the consecutive mode. Allow the question to be asked, interpret the whole question, allow the answer to be given, and interpret the whole answer. The LEP or an NES is part of a question-answer exchange, whether it's not at the even if it's not at the position, even if they're not at the witness stand. Let's say they're in front of the judge, and the judge is asking some preliminary questions like, do you understand what you've been charged with during an arraignment? Any time that the LEP or NES is part of a question and answer exchange, you must be using the consecutive mode. When do we use side translation? Well, that should be pretty obvious. If the interpreter is called to read documents written in English for the benefit of the LEP, you should do side translation. When the interpreter is required to read documents written in a foreign language for the record, you should be doing side translation. Finally, when do we use simultaneous? Simultaneous should be used anytime the LEP is present and their case is being discussed by other parties in English. That is the rule. And if you think about it, when we do more simultaneous than anything else, we use more the simultaneous mode than any other mode of interpretation during hearings, trials, anything that has a lot of discussion in English around the LEP. Interpreting in the simultaneous mode is the way we interpreters allow the non-English speaker to be linguistically present during hearings, trials, and anything that has to do with their case. Not only physically present, but linguistically present. Thank you very much for attending this first module. We are going to continue with the next module. Thank you very much.